Good afternoon. Thanks everyone for joining us today. This webinar is hosted by the ABA's Ad Law section, specifically the Committee on Constitutional Law and Separation of Powers. And today we have three experts to talk about the Supreme Court's decisions at the end of the most recent term, dealing with administrative law and constitutional issues related to the operation of Article 2. The court's decision in both Arthrex, dealing with the Appointments Clause, and the Collins decision dealing with the removal protections covering executive branch employees. And we've got with us today Professor Melissa Feeney-Wasserman, the Charles Tilford McCormick Professor of Law from the University of Texas at Austin School of Law, Professor Aaron Nielsen, who's Professor of Law at the BYU's J. Reuben Clark Law School, and John C. Harrison, the James Madison Distinguished Professor of Law, and Thomas F. Bergen, Teaching Professor of Law at the University of Virginia School of Law. They were all involved in a significant way in this litigation. Professor Wasserman's article on agency adjudication, co-authored with Professor Chris Walker from the Ohio State University School of Law, was cited in both the majority opinion and the Justice Gorsuch's concurring opinion in the Arthrex decision. Professor Harrison submitted an amicus brief in Collins that was cited by Justice Thomas's opinion in that case, and Professor Nielsen participated in the Supreme Court arguments in Collins. So we're really looking forward to the discussion with this panel of experts today and how the court's most recent decisions will impact the staffing and supervision of executive branch agencies and departments moving forward. So what we'll do from a formatting standpoint is we'll begin with each professor giving some opening remarks, summarizing the holding of the decisions and then significant implications of them. We'll leave time for the experts to respond to each other, a time for moderator questions, and then some time for audience questions at the end to the extent anyone following along would like to engage more directly with the panelists. So thanks everyone for your time, and Professor Wasserman, to you for a discussion of Arthrex.
So thank you very much, Professor Mascott and the ABA for putting on this panel and inviting me to be a panelist today. I'm really excited to be part of this. So what my opening remarks are going to do is help summarize the Arthrex case, and then I'm just going to provide some thoughts or some preliminary thoughts that I had on this particular case. So Arthrex is a case that raised an Appointments Clause challenge to administrative patent judges on the Patent Trial and Appeals Board, otherwise known as PTAB, that's at the U.S. Patent and Trademark Office. So PTAB was created in 2012 as part of the American Invents Act, and it provided for the first time this robust, streamlined pathway in which third parties could ask the PTO to take a second look at an issued patent. And PTAB was conceived to be this cheaper alternative to district court litigation, and it proved to be immensely popular. The agency received something to about 15,000 petitions since its inception, which was more than 3 times the amount the PTO was expecting. And PTAB adjudication is really a formal-like adjudication, and you have 3 APJs that sit on panels to decide cases. So there are really 2 issues before the Supreme Court and Arthrex. The first were APJs, principal inferior officers, and if they were principal officers, then there was likely an Appointments Clause violation. Second is if there was a constitutional violation, what was the proper remedy? And the court was deeply fractured on the decision. So there are different majorities, both with the merits and the remedy in Arthrex. So on the merits, it was a 5-4 decision, and what the court did, which was very similar to the Federal Circuit, which was the lower court who decided this, they engaged in a very formalistic interpretation of the Appointments Clause. And under the statutory provisions of the Patent Act, the director really did have a significant level of supervision and oversight over APJs. And really at one time, what the director would use was something called panel stacking to sort of ensure that PTAB outcomes came out the way the director wanted. And so this would involve an initial decision occurring, and if they got a rehearing, it would be granted, and the director would expand the panel to include additional members and appoint additional APJs on the panel in hopes that the outcome would come out the way the director wanted. And so even though the director had these different functional ways in which they controlled PTAB, importantly, the director did not have the power to review and reverse PTAB decisions directly and could only remove APJs for such cause that will promote the efficiency of the service. So the Supreme Court held really as a constitutional matter that only principal officers could issue these final decisions that were binding on the executive branch. And because administrative patent judges issued final decisions and weren't appointed by the president and confirmed by the Senate as principal officers are required under the Appointments Clause, that this was a constitutional violation. So then the second issue before the court was, what is the remedy? The Federal Circuit had also found a constitutional violation, and they remedied the situation by excising the removal protections for APJs, such that you could remove them at will. And basically, I felt like no one was really happy with this remedy, right? People weren't sure it fixed the constitutional violation. People argued from a policy perspective, this was a bad decision because it really just increased constitutional tensions between having independent adjudicators, right, and having an agency head who controls agency adjudication. And so I wasn't surprised that the court didn't follow the Federal Circuit's remedy, but I was somewhat surprised that the court found that the Patent Act, as written now, gave the director final agency head decision-making over PTAB. And more specifically, what the court did was find that because Congress had vested the director with the powers and duties of the PTO, that this essentially gave the director the ability to review PTAB decisions and to issue them on behalf of the board. Now, interestingly, TTAB, I just thought Congress would do this and step in. So on the trademark side of the Patent and Trademark Office, there's something called the Trademark Trial and Appeal Board, which is basically very structurally similar to PTAB. And what Congress had done after Arthrex came out in Federal Circuit had quickly granted, right, the director the ability to have final agency review over the TTAB side. But on the PTAB side, there was more disagreement on how to move forward. So let me just say just a few closing kind of thoughts. From a normative perspective, I thought once the court found a constitutional violation, I agreed that the best remedy moving forward was to give the director final agency head decision making. And as Professor Mascott had noted, I've written a piece with Chris Walker that was entitled "The New World of Agency Adjudication." And what we did was compare PTAB adjudication to other kind of type 2 adjudication, which are these very formal like adjudications, but may not rise to meet the APA definition of formal adjudication. And one of the things that we found that was an odd feature of PTAB was that it lacked agency head review. And in this article, we argued there was good policy reasons to give the director final agency head review over PTAB decisions, including this ability to ensure that the decisions aligned with the policy preferences of the director, as well as enhancing consistency across PTAB decisions, and to give the director a better kind of understanding of how well the regulatory system is functioning. And we also argued that this is far more preferable than having this kind of functional approach that the director did through panel stacking or these other ways that they attempted to try to control PTAB decision making. And then the last thing I'll sort of note is that I think you can also think of Arthrex as this kind of reaffirmance of this theme that the Supreme Court has said in administrative law and patents, that is, patents aren't really exceptional. Now, I think we're all kind of guilty about this in our field. I love to think that patents are special, right? And IP scholars, we all think IP is special, but the Supreme Court has kind of many times told us, no, it should fit with the sort of administrative law. And so what I think in part is going on is that this 2012 American Invents Act really raised the stature of the Patent and Trademark Office and gave the agency some new powers, this formal like adjudicatory power, among other things, that really sort of elevated the status and more on par to modern administrative agencies. And so you've seen a lot of legal challenges to these new powers. And I think you've also seen the Supreme Court repeatedly saying, no, this agency adjudication is like others. And so you can think of Arthrex as another way of the court saying, yes, you have PTAB adjudication, but it needs to have final agency head decision making like the vast majority of agency adjudication does in the administrative state. So that's what I have. So I think, Aaron, are you next?
Yep. All right. So Be warned, Collins v. Yellen is a mess of a case that's worth over $100 billion. So bear with me. We're going to go through some complicated facts. There's a payoff at the end. You'll see why I'm going through the whole story. But there's a lot going on in Collins, and it all starts with Fannie and Freddie. Fannie Mae and Freddie Mac, two congressionally chartered mortgage intermediaries, massive players with trillions of dollars on their books. Well, during the housing collapse in 2007 and 2008, those trillions of dollars on their books suddenly became much less valuable. And there was real concern that Fannie and Freddie were going to collapse and bring with it a huge chunk of the economy. So Congress in 2008 enacted the Recovery Act and created a new federal agency called the Federal Housing Finance Agency. And this agency is headed by a single director, and the director can only be fired for the president for cause, but otherwise has a 5-year term. And what happened was, so now you have this new agency, and the FHFA has the power to act as a safety and soundness regulator for Fannie and Freddie and the home loan banks. So they can check to make sure the books are all right. They can do audit kind of stuff. But they also have a new power, which was they can act as either conservator or receiver of Fannie and Freddie. So in 2008, after Congress enacts the statute, the FHFA and the US Treasury enter into an agreement. And the Treasury Department gave to both Fannie and Freddie $100 billion of access to funds from the United States. In exchange, Fannie and Freddie gave a bunch of things back to the government, including they would pay fees for access to that money. It soon became apparent that that was not nearly enough money to save Fannie and Freddie. So the United States doubled the amount. So now both Fannie and Freddie had $200 billion that they could spend. That also wasn't enough, so they amended the deal again. And through 2012, they could spend as much as they needed of the federal money to save them from collapsing. Well, fast forward to 2012, and this is what the case is about. They enter Fannie and Freddie in the conservatorships enter into the Third Amendment, or the network suite, with the Treasury. And what they decided was, instead of you paying us money on a periodic basis for access to these funds, here's the new deal. Every time you make money, you give it to us with a little buffer you can keep for yourself, but you give it to us, us being the United States Treasury. But when you don't make any money, you don't have to pay us anything. So that way, Fannie and Freddie, when times were good, they would turn over essentially all their money to the United States. And when times were bad, they didn't have to pay anything. Well, the private shareholders in Fannie and Freddie viewed this as a nationalization of their investment. Fannie and Freddie have private shareholders. They serve public functions, but they are for-profit businesses. So immediately following the network sweep or third amendment, you had litigation all over the United States, including in the Fifth Circuit. And in the Fifth Circuit, there were two main types of arguments. One was, what you're doing, FHFA, as conservator, exceeds any reasonable definition of conservatorship. You're taking all of this money for the United States that really should stay with the companies. And conservators' job is to conserve what you are tasked with, not to take from for your own aggrandizement. So there's a statutory argument that this is unlawful. But they also raise, and this is the particular relevance here, a constitutional challenge. And they say, what kind of federal agency is headed by a single person that the president can't fire at will? We know Humphrey's executor says you can have a multi-member body. Okay, whatever. But this is a single person, and that can't be constitutional. So the Fifth Circuit says, we think that the FHFA exceeded its authority as conservator. We're going to send it back for a trial on that. But we also think that the FHFA structure is unconstitutional because the president can't fire the director at will. But as remedy, the Fifth Circuit said, what we're going to do is, rather than invalidating the Third Amendment and giving you back, $100 billion, instead, we're just going to say we're going to sever this provision from the statute. So now going forward, the president will be able to fire the FHA director at will, but not, you don't have to undo everything. Well, while all this is happening, I'm sorry, it's complicated. Sailor law gets decided last year. That's about the CFPB, a very similarly structured agency, a much more powerful agency, but a similarly structured agency. And there, in a 5-4 decision, the Supreme Court said the president can fire the CFPB director at will. So now you have the United States petitioning in Collins saying that the Fifth Circuit's conservatorship decision is wrong. You have the private petitioners and Collins saying, yeah, we're entitled to more of a remedy than just a severance. We actually want our money back. The United States refuses to defend the agency. So I get brought into this case. I'm appointed as amicus to defend. And now here's the takeaway from the Supreme Court's decision. 3 main holdings. Holding number 1, the FHFA did not exceed its authority as conservator. It's true that maybe it was benefiting the United States and the agency in ways that were not always helpful to Fannie and Freddie. But the statute says, as conservator, they can consider the interests of the entities or of itself. And the Supreme Court says, you know what, Congress meant what it said. So if it looks like a nationalization, whatever, that's okay. It falls within the broad conservative powers of the agency. So right now, Fannie and Freddie are controlled by the FHFA. You know, they're still nominally private, but at this point, they're almost federal instrumentalities. Like they're just being controlled by the government. Number 2, and this is particularly relevant, they say this structure is unconstitutional. I came up with a number of arguments to try to say why the CFPB and the FHFA are different, and the Supreme Court did not buy any of them. So what does that mean? I say, look, the CFPB exercises way more power than the FHFA. You even said that in Say La Law, and the Supreme Court essentially said, yeah, but you know what? Any amount of power exercised by the agency, if it's executive power, the president has to be able to fire. I said, but this is a conservatorship. That's not even executive power. Private people are conservators. You know, see Britney Spears. So we know that this is an executive power. And the Supreme Court says, yeah, it's executive power. This isn't an ordinary conservatorship. I said, but look, these aren't private people being regulated. These are 2 government companies. This is you know, a public-private rights type distinction here. And the Supreme Court says, no. Whether that's who they're regulating doesn't matter. All that matters is executive power. And finally, I say, but look, you can fire the FHFA director for cause, not inefficiency, neglect, or malfeasance, for cause, which statute says if they disobey the president, you can fire them. How can it possibly violate the Constitution, my argument, if you can fire the person for disobeying the president for policy disagreement? And the Supreme Court says, yep, we recognize that, but even so, because the president does not have confidence in the head of the agency, they can fire at will. This is the most pro-unitary executive decision ever. You could say Myers, but Myers is dicta. This is all holding. So you say, well, wait a minute. So I guess this means that the private parties are going to win, you know, the $100 billion, to which the Supreme Court says in its remedy decision, not so fast. The mere fact that you are not there's a removal provision does not mean that everything the agency does is per se unlawful. Instead, you have to show that, you know, but for that removal provision, things would have happened differently in the alternate reality that didn't happen. Justice Gorsuch disagreed with the court on that and said, how are they even supposed to make that showing? But nonetheless, 8-1, they say that. So the takeaways are, we have a very, very powerful conservator floating around out there. Most pro-unitary executive decision, like I said, I think ever. And then the third, but the remedies are really hard if you're a private party. So the takeaway going forward is, how far does this decision go? You know, we can talk about that in the back and forth, but, you know, I had, you know, a parade of horribles saying, if this goes, where does it end? You know, Social Security Administrator, is he gone? What about heads of single-headed multi-member agencies for which the chair has their own power? Well, the postscript, of course, is as soon as the court decides Collins, President Biden fires the head of the FHFA, and several weeks later, they end up firing the head of the Social Security Administration. More to come on that, and I think that's a good summary of the case.
Fantastic. So, John, we look forward to hearing from you now, Professor Harrison, on the remedies and whatever else you would like to bring from your extensive scholarship experience and also past executive branch experience to the analysis.
Well, thank you. I am going to talk about the question, what happens next? By which I mean not what happens next now that the court has decided these cases, but what happens next in a case once the court has found that a statutory system is unconstitutional. I'm going to break that question, what happens next, down into 4 questions. One question is, well, if the law is not what the statute says it is, what is the law now? Second question, when did that become the law? Which I think is quite important, and I'll talk about why it's important in a moment. Third question, given what the law is and whenever it was it became the law, what are the implications of that for the lawfulness of official decisions, like the decisions in the Arthrex case? And then fourth, in light of all that, what should the court deciding the case do in that case? And one thing I want to say is that last question, what should the court now do in the case? That's the question of remedy, strictly speaking. All 4 of these issues are often described as remedy. In a sense, they are remedies, but it's the last one, what's the court going to do, is the real remedies questions. First thing I'm going to talk about Arthrex, then a little bit about Collins. The standard problem in an appointments clause case like Arthrex is there may be a mismatch between the character of the office, administrative patent judge, and the appointing authority. Only the president can appoint a superior officer, head of department can appoint inferior officers. These officers were appointed by a head of department, meaning their job has to be one that is that of an inferior officer. The Federal Circuit said, sorry, this is too much for an inferior officer. Then asked the question, okay, if that statute's unconstitutional, what's the law now? The question they'll often put up in terms of severability, or here, where you have a lot of statutory provisions working together, what's the fallback arrangement? The Federal Circuit said the fallback arrangement is at-will removal for PTAB judges. And, okay, so that's what the law is now. They are removable at will. And, said the Federal Circuit, that became the law only when the Federal Circuit said so. So as they put it, we have now fixed the statute, and the statute isn't what it used to be. The statute used to make these officers not freely removable. Now they are freely removable. So the Federal Circuit's actual remedy was to say all of the decisions made up until this point are invalid because they were made by officers that had invalid appointments. I think that was a mistake. What I suggested to the court in my amicus briefs in both those cases was whatever if a statute is unconstitutional, it becomes ineffective at the moment it's adopted. The Constitution doesn't wait. The Constitution itself makes an unconstitutional statute invalid, and at that point, whatever is the fallback arrangement that goes into place. So from my standpoint, the Federal Circuit was wrong in thinking they had changed the law. Now, the big idea, I think, is on these issues, courts don't make law, they find law, and so they find what the law already is. They don't change it. Chief Justice Roberts said some very interesting things for the court, said this is unconstitutional, and very much integrated the appointments clause about the inferiority of inferior officers with the Article 2 vesting clause, the unitary executive principle. So those two now go together more than they used to. The Chief Justice's fallback solution was review authority in the director. I think that is extremely interesting because despite what Collins says, that the only way to ensure presidential control is removal power, well, apparently the court, at least for an inferior officer, which isn't quite the Article 2 thing, but the court's made it very close, thinks that control over the officer and not removal is enough. Now, I think that's right. I believe in the unitary executive principle, but I don't think that it needs to be implemented by removal. I think control is adequate. So I kind of like what the Chief Justice said there, but whether I like it or not, the important thing is that's a significant idea, that an adequate form of control is supervision and direction of the decision rather than the ability to remove. Having said what he said, the Chief Justice said, well, the appropriate remedy in this case, what do we do now, is tell the officials to conduct this proceeding again, because, and here I think just sort of a standard remedial principle, standard kind of ad law principles. What happened was officials decision about Arthrex, but they followed the wrong procedure. The statute's unconstitutional. The real law is, and has always been, I would say, that the director has this power to review. So said the Chief Justice, redo it, This time we're going to tell you the director has the power to review. Use the right process. Now, Justice Gorsuch disagreed as to what the law is now. The point, once the court has decided that the law is written in the statute isn't the law because it's contrary to the Constitution, well, now what's the law? He said the law is this entire system of inter partes review is now inoperative. The whole thing goes out, not because it's all unconstitutional, but only the combination is unconstitutional. No particular part is unconstitutional. But said Justice Gorsuch, the way these severability fallback type inquiries should be conducted can't be the courts just deciding what they think the statute should say. And here he said, we have no guidance from Congress. All we're doing is coming up with our own solution, and therefore we should say that the entire system is inoperative. I think Justice Gorsuch was half right. He was right that the court had not gotten any guidance from Congress about what the fallback system is. Sometimes Congress does legislate a fallback, but they didn't here. That's true. I think Justice Gorsuch was wrong to think that there was any reason to pick the solution he picked, which is the whole system became inoperative, because there are other ways in which the statute could continue to be constitutional. The important thing to see here, I think, is when it's the interaction among different parts, like the mismatch between the nature of the office and the appointing authority, when it's a whole system that is unconstitutional, but each part isn't separately unconstitutional, and everybody agreed with that, then the Constitution doesn't answer the question. The Constitution doesn't say what the law is. All the Constitution says is what the law isn't. And it's going to be necessary to look somewhere in the statute to find out now what the law is. And when there are different possible answers, like the Federal Circuit's answer, like the Chief Justice's answer, like Justice Gorsuch's answer, or like the answer that the solution is presidential appointment and nothing changes about the officers, the courts have to pick among those with no guidance either from the statute or from the Constitution. So insofar as Justice Gorsuch suggests that there's something special about the remedy he proposed, well, there is nothing special about it. I think one thing the court, if they see more problems like this, where it's a collection of provisions that as a whole are unconstitutional, the justices are going to have to come up with some way of dealing with that situation, because they can't just use ordinary severability. They can't just say the unconstitutional part goes out, because no one part is unconstitutional. Appointment by a head of department is okay if it's combined with an inferior office. They need to develop some principles, probably some principles that are just, rough and ready. Here's our guess. Congress, please tell us more. But understanding that the Constitution isn't telling them what the solution is. Okay, now about Collins. Collins, interesting problem. It's a constitutional problem with a removal restriction, but it's not a removal case. Not a case in which an officer was removed, like Humphreys was, like Myers was, and said, I was wrongfully removed. I want back pay. So the easy first step, what's the law? The law is the unconstitutional removal restriction is not operative. The next two questions, what's the law now and when did that become the law, then are an interesting part of Collins. Because what the parties said was, the law is that the removal restriction has been, as we would say, and I don't like this terminology, struck down by the court, so that now, as of the court's decision, the officer is removable, but previously the officer was not removable. That was unconstitutional, and therefore the officer can't act. That's what the plaintiff said, and basically the government agreed with them on this point. I think that's wrong. Again, I think, and this was the burden of what I suggested to the court as amicus, is if a statute is unconstitutional, it is inoperative as of the moment it is adopted, because it's the Constitution that makes it invalid. That's not something the courts do. That is something the courts find. And so it's a mistake to think that there is such a thing as an unconstitutionally non-removable officer. That can't happen. If the removal provision is unconstitutional, the officer never was unconstitutionally non-removable, even if parties thought that that was what the situation was because they didn't know what the law was. And on this point, the court said that the invalidity of the unconstitutional provision happens ab initio. Here's Justice Alito for the court. Although an unconstitutional provision is never really part of the body of governing law, because the Constitution automatically displaces any conflicting statutory provision from the moment of the provision's enactment, it is still possible for an unconstitutional provision to inflict compensable harm. So the court said invalidity, the operation of the fallback, which is here simple severability, goes into effect upon enactment because the Constitution does it, not the courts. And Justice Alito then raised some really interesting questions that Aaron mentioned a moment ago. There's going to be a remand to ask a counterfactual question. Well, what would have happened if everybody had known what the law really is? Because what the law really is all along, the director of the FHA has been freely removable. The court, to the best of my knowledge, has never ordered a remand like that before. And so the first thing the lower courts are going to have to figure out is, what's the question? What is the court telling us by asking us to sort of reconstruct history? And then what is the answer? Justice Thomas in concurrence agreed with Justice Alito in the court about this point. When the unconstitutional provision becomes invalid, it becomes invalid on adoption. It never goes into effect because the Constitution itself invalidates it. He thought this was an easy question on remand and raised the issue for remand. Maybe this problem should be understood as a question of administrative law. There was an error by government decision makers about what the law was. Does that mean, as Justice Thomas said, that their positions were arbitrary and capricious because they got wrong an important fact about the system in which they were operating? Justice Gorsuch said, no, this is wrong. The actions of the officers are unconstitutional because an unconstitutional agency can't legitimately exercise power. I will say, I don't think that's right. I think the idea that there's a large category of unconstitutional agencies is a mistake. It's necessary to break this down. And one thing the court and Justice Thomas noted was there is no problem with, as far as the Constitution is concerned, with the grant of power to the FHFA. The problem here is with the removal restriction, but the removal restriction is invalid. And as I say, that's why I think both of these cases are, among other things, fundamentally about this question: when does the invalidity of an unconstitutional statutory provision arise, and what then are the consequences of that for the timing of various legal events? And again, my position is invalidity arises ab initio because the Constitution does it. It's not the courts doing it. Thanks.
Okay. That's very fascinating and intriguing. And I feel like there's a lot for us to sink our teeth into because, we've had very different comments from the first two panelists talking more about the substance of the decisions, and then Professor Harrison talking about, the back end. What do the decisions mean? What does a finding of constitutional error mean? And of course, there's lots of disagreement among the justices, and then that could have a lot of broader implications for this case. So before we get down to specific follow-up questions, I wanted to give each panelist a time to respond how they feel is important to whatever themes came up in the others' remarks. To the extent that you don't have, a particular strong observation, one thing we could generally think about is what we think the implications of each decision are moving forward. So Professor Harrison, and really all of you spoke to this a little bit, but in Arthrex and Collins, are there such obvious implications for other administrative structures or for cases that we know are coming down the pike that audience members should be thinking about the broader implications of these cases in a particular way? So I guess, Professor Wasserman, I'll go first to you.
Yeah, so I'll keep my comments more on Arthrex. I think, what are the implications of that case? I don't think they're incredibly far-reaching because I think PTAB really, as I noted in my initial comments, was kind of an outlier in that most adjudications similar to it have already final agency head review. Now, of course, sometimes they've delegated that and they have some sort of intermediate panel, et cetera. But it was a rarity, right, for us to find agencies that lacked it. So there were other examples, certainly, but I just don't think it's as far-reaching, right, as as we may have, or at least initially thought, because I think PTAB was a little bit of an outlier. I think clearly TTAB, the Trademark Trial and Appeal Board, was the one that was going to be most affected, and Congress kind of stepped in and gave the director review over TTAB almost immediately.
That's helpful. So, I mean, if we're looking just at whether there are other analogous agencies on the facts that are immediately going to be impacted, the answer here seems to be no. Whereas I think Professor Nielsen suggested that there might be, depending on how broadly you read Collins, a different answer in that context. But Professor Wasserman, what do you think about, or others, about Professor Harrison's separate point that it sounds like the court is starting to tie the vesting clause and appointments clause requirements more closely together, and suggesting that supervision can be done more in front end direction than removal? And this can be for Professor Wasserman or really any of the panelists. Is that just, I mean, maybe right now that's just theory, and so litigants need to come up with a case to bring. Is that right? Or do we think that distinction of where does the supervisory authority derive from in the Constitution is going to have general implications, even if there aren't similar agency structures to the PTAB that might be immediately impacted by the precise holding?
Yeah, I don't know if I have a lot to, I mean, I think generally that yes, this move to control, I mean, that was one of the differences I saw in Arthrex, rather than doing it kind of on the back end, right? They're doing it on this front end and requiring there to be sort of agency head review, which I think was different. But I don't know, I would like to hear kind of what the other panelists have to think about that.
Maybe Professor Harrison, since you made the observation, I mean, what are your thoughts? Is this just a theoretical distinction that's not going to have any practical impact in other cases?
Two thoughts. First, specifically about the appointments clause. I think that this shows that, because there was a serious disagreement among the court about exactly how the inferior officer, superior officer distinction works, that this indicates that a majority of the court, not apparently including Justice Thomas at this point, takes a very much hierarchical view of the difference between superior and inferior officers. That to be inferior means to be inferior in a hierarchy, to be under somebody's direction. They now seem to say that, and that's why I say I think integrated with the idea of unitary executive presidential control. I think on the question of what kind of control, it seems to me that there's now something of a tension between Arthrex and Collins, because since the court in Arthrex talked about the appointments clause as part of the system of presidential control and said, and the ability to reverse a decision, even without removal power, is adequate. Well, how does that match with what Collins says, and as Professor Nielsen talked about? Well, removal for cause is not enough. And I don't know if there's sort of a statute, a case that would raise this point. I think that question that would come up would be if a statute explicitly says, doesn't just imply, as probably the statute for the FHA implied, if a statute explicitly says that removal for failure to follow the president's policy is legitimate grounds for removal, I wonder, would the court stick with what they said in Collins, or maybe looking to Arthrex, they might say, well, Congress has now come out and said that, and that's adequate control. And one thing I'll point out is that's how it works in the most hierarchical part of the executive branch, which is the armed forces. They have to follow orders and are subject to sanctions for not following orders, but the sanctions don't necessarily include removal. So I think that point too might cause, with statute that really focuses on this, might cause the majority justices to rethink this point.
That's interesting. And I want to give Aaron some time. The other thing I want to ask you all, I mean, because John, I agree with you. When I read Arthrex, the thing that jumped out at me too is it seemed as though we were really moving to the front end with instruction and direction. But what I realized when I talked to folks, some of whom, might have been very aware of the decision and thought about it a lot, I got the sense that perhaps, I don't know. Do we think that the language in this opinion is the kind of thing that law professors might sit around and see great import in, but perhaps the court just was really concerned about the remedy and for whatever reason thought that the severing of the removal protections was going to be more intrusive because of the portion of the patent statute that already apparently allows the director to run operations. And so in trying to be modest in the remedy, maybe it sort of back-ended or backstepped into this other instruction phenomenon and didn't actually mean to make seismic shifts in how we see hierarchical direction, which would explain maybe why it wouldn't have seen the decision it handed down in Collins just a few days later or a few days different in time as in conflict. I don't know. Aaron, do you have thoughts on this since you argued Collins and have clearly thought through the holding and reasoning of that case quite a bit?
Yeah, so this is kind of a funny anecdote about the process. So, Melissa noted that Chris Walker wrote the article with her. Well, Chris Walker also co-authored my brief with me. When I got appointed, I'm like, I need to assign somebody who could help me write. So Chris generously joined the team. But we had a moot getting ready for the argument. So this is about a week before the argument. And the nice folks at Stanford agreed to give us a moot. And Ann Joseph O'Connell was one of the mooters. And you talk about an academic question. This stuff kind of came up because Professor O'Connell is just a master of this stuff. She threw a question out there about, well, how does this relate with Arthrex? How is this all going to sync up together? And I confess that my jaw just dropped. And I'm like, don't tell me this a week before argument, because my brain is already so full. But we had a very academic discussion about how all of this kind of might fit together. And I'd be curious to hear, I wish Anne were on the line, her thoughts on this, because I think she has had the vision of the two of the cases before they came together. I'm not sure how that's going to play out. Candidly, I don't think the court quite is sure how it's all going to play out together. One thing you had mentioned about implications for other cases, I raised in my brief, well, what do you do about the civil service? And in particular, one, just any member of the civil service, what power does an FBI agent wield, if not the executive power? So does the president have the power to remove that person too? But leave that aside. Let's talk about the people that are nominally employees, but maybe are really officers. And how does that work? What do we do with those folks? And I raised that in the brief, and the Supreme Court in Collins has a footnote that says, we're not talking about the civil service in this case. We're saving that for essentially we're saving that for another day. So I'm not sure if the logic of Collins, if one way you square the circle here is they say, you know what, the president has the power to control what you do, and the president has the power to fire you. The president has both. It's not an either or. That might very well be the end game here, at least the logic of if it's the executive vesting clause doing the work. Why does it not end with anyone who's exercising the executive power can be removed, and these civil service protections that we have floating out here, or the military protections, you know what, those actually just aren't good law either. We don't know the answer, and the court pointedly did not offer a limiting principle.
Well, I mean, I agree with you that if you follow the principles out of Collins, that it seems awfully hard, first of all, to believe that Humphrey's executor still really has import. And then you start wondering about the removal protection for all the other offices. But because the court does like to issue what in its mind are limited opinions and then say we're not answering all of these other questions. And, Professor Harrison's pointed out the distinction between Arthrex and Collins. I wonder if more of the court will see it as if it has two options moving forward, right? So in the FBI situation, if we think these are folks where they need to be independent and can't be fired for not following the political will, do we just allow a little bit more direction on the front end, but not allow them to be fired, or vice versa? Does the court now just have more options of how it can fix unconstitutional statutes in the future?
I have a thought about this,
Mhm.
which is first I think you're absolutely right that the court came up with the solution they did in Arthrex for reasons specific to Arthrex, and so it's amazing. The opinions came out within a week of one another, and they didn't see this problem. And maybe they are more committed to what they said in Collins than this possibility in Arthrex, but maybe not. And I think one thing that is possible, having mentioned the armed forces, and now that the civil service has been brought up too, I think it is possible that the court might find that for people who are officers, not employees, say, they have to be subject to some kind of hierarchical control, but it doesn't have to be removal. But that for very high officials, and Myers kind of intimates this, maybe for very high officials that have a very confidential relationship with the president has to have, I don't think this is true, but I can imagine the court thinking it, the president has to have removal power because the president has to think, this is somebody I can confide in. This is somebody I personally trust. It's not just, is this person going to follow orders, but is this somebody who is really with me and part of the team? And maybe for very high officials, it has to be like that. So I could imagine they're saying, as you say, more options, or maybe the different ways of getting presidential control are adequate depending on where in the hierarchy and how close to the president somebody is.
Interesting. Does anybody have a response to Professor Harrison before we change topics a little bit? So I think, some folks in talking about these particular decisions or issues like them have also raised questions about the notion of due process or the modern conception of due process. So at least in the agency adjudication context at issue in Arthrex, we've sort of come to think as a matter of contemporary law that we want adjudicators to be a little bit more independent. Now, after this decision, the director, in theory, even if he doesn't do this in practice, can review all of the decisions and change them, presumably, or require reconsideration. Are there due process concerns raised by the outcome in Arthrex or Collins, but principally Arthrex?
So I would just say, I mean, that's been our structure, right, of modern agency adjudication, right, is that you've always had what APA formal adjudication, right, and most of this sort of formal-like adjudication has always had the director being able to reverse, right, the adjudicator. And so it's always, this is kind of the tension that they talk about with respect to agency adjudication. You want this sort of lower level independent adjudicator, but then you have this political control over the director. So I feel like that's always been baked into the system. And I'm not sure that the Arthrex case would raise additional issues.
Okay. Anybody else have thoughts on this?
Yeah, I think that one thing that this reminds us of is that agency adjudication is used both to do just plain old application of law to fact, but also to make and implement policy. And the important thing here is to make sure that when you've got review by an agency head, as the system now has, that the agency head is reviewing either to make new policy or to make sure that the lower level decision was consistent with policy. And again, on the unitary executive, one of the big unitary executive questions is, well, the president shouldn't be reviewing adjudicatory decisions. The president doesn't review the record. And I think that, and I hope there's some way to do this, I think there the proper solution for a Unitarian, such as I am, is to enable the president to control policy the way an agency head can control policy, while leaving what you might think of as the real adjudication point, the application of law to fact finders who can be independent. And again, I think that's consistent with the unitary executive principle, because I think the real key is for the president to be in charge of policy. And what happens within an agency can also be true in the relationship between an agency head and the president. Somebody's in charge of policy, somebody else is in charge of what you might think of as the adjudication part.
final question from me before we head to audience questions, because we do have several. So if that's right, and Arthrex is changing things and allowing maybe the director and ultimately the president or the Commerce Secretary to more clearly direct policy, is the outcome in Arthrex more far-reaching than if the court had taken the Federal Circuit's approach? I mean, or did the court come up with the most modest remedy here that it could? What do folks think about the propriety of the way that the court decided to address the constitutional question? I know, Professor Harrison, you've talked about lots of broader issues about remedies and when the constitutional error actually occurred. Was this the proper, modest outcome in this particular case?
I'm going to say, actually, I think it probably was. And again, as I mentioned, Congress has sort of left the court at sea here. And so the court has to kind of feel its way in finding out what the fallback system is. But if you think that the point of the structure that Congress created is to have adjudication by adjudicators and then policy control by higher up, I think the solution the court came up with, the fallback system that they sort of found in the statute, although it's not there explicitly, probably does the best job of implementing that underlying policy. And that saying there can be free removal of adjudicators probably would not properly achieve what Congress is trying to achieve. Whereas what the court said, yeah, what I think is basically policy from a policymaker, adjudicator from the adjudicators, makes sense under the statute and kind of more broadly as a policy matter.
Great, Professor Wasserman.
No, and I would just echo again kind of what I noted before. I mean, this is the blueprint, right, for agency adjudication, right? Most of them have, ALJs, right, or that have more protections even than APJs or the administrative patent judges, and then you have director review, right? And I think for the reasons in part that Professor Harrison said, this has been the model that we've had in the system. So, and that way of looking at it, yeah, I would think it's more modest. It's just aligning PTAB more generally with what we've had.
And what about from a statutory interpretation standpoint? Do you agree with the court that that it's possible to read the statute as already providing the framework for director review?
I mean, no. I mean, I just don't think that's what Congress intended. I don't think anybody in the patent field or patent world thought that the Patent Act, right, and this 2012 American Invents Act gave the director review. And interestingly, well, a little factoid, right? The director way back when, 100 and something years ago, did have final review of the predecessor. It wasn't PTAB, but of the predecessor. And Congress removed that in part because they were concerned about the volume of cases the director would have to review, and then put in this like weird structure that we have now where there's 3 APJs and the director and other high-ranking officials could serve as members of the panel as well. So, I mean, that seemed like to me pretty strong congressional intent that Congress did not think the director had this authority. So, I said normatively, I agreed with the result, but I was surprised, right, that they found it within how the Patent Act was written today.
Hey, Jen, just 1 second, if I may. Not about that specific question about the statute, but the broader idea that agencies should make policies by adjudication, which seems to be what there's did in Arthrex. I think that's quite problematic. I think there's other problems with that, even though they're trying to make it more uniform to the admin law. Admin law, I don't think is great on that point. So unifying patent adjudication with general principles of admin law there strikes me as problematic, because you have very serious fair notice problems when you have law made by adjudication by somebody who is a political actor. That causes real unfairness to people who try to rely on what they think the law is, and they just have it, taken out from under them, not through a court, but by some agency official. That's maybe a problem for another day, but I am concerned about that kind of direction of Arthrex.
Can I just respond very quickly? Yeah, I would say yes, and I think it's unfortunate that the PTO doesn't have broader sort of substantive rulemaking. right? So it's this weird agency that has very limited substantive rulemaking, so they can say, you know, what the core patentability standards have. And I feel like they're left with these very awkward ways and try to do policy. So maybe perhaps they should be doing more even through the rulemaking authority that they have. But I think some of it's handicapped by the limitations that they have.
So we have questions actually in the chat function, but also coming through the Q&A box. So I'm going to start with the Q&A box. And the first question, and we've talked about this a little bit, but more specifically, folks are interested in knowing whether you all agree that there's now irreconcilable tension with Humphrey's executor and tenure protections for multi-member commission heads, either because of the Collins holding, or I myself think some of the dicta, at least in Arthrex, about transparency seems incompatible with multi-member tenure protected commissions. Do you all agree?
Yes, I don't see how to reconcile the two other than just stare decisis. But even if you look at, this is Saylor Law, not Collins, how the Chief Justice explained the holding in Humphrey's executor, that is a very narrow conception of what the court held in Humphrey's executor that may not even apply to today's current FTC, much less to other agencies. So I don't see how they reconcile, and I don't think that they are trying that hard to do so either. I don't think they see Humphrey's executor as a sound premise from which to reason.
Well, I agree with you. They don't see Humphrey's executor as a sound premise, but I'm not sure I'm convinced that I guess it's different ways to read it. I mean, one cynical way to read it is to say, maybe the Chief Justice really does hate Humphrey's executor in principle so much that he intended to overthrow it in all but name, and he just simply doesn't want to say it's overruled. But I think it's possible that there might be members of the court who actually believe that they have created a patchwork now that is all consistent, because they would say, like, what if you start from the premise that Myers is the law and everybody can be removed at what needs to be able to be removed at will, except in the cases with high-level officials where the court has found longstanding practice that you could have tenure protections. And so we're leaving that longstanding practice in place. And everything that doesn't appear exactly like it, we're going to say is inconsistent with Myers. And then voila, we keep Humphrey's executor in place. But unless you make sure in the future you match your structure totally with what we said is okay there, you're out of luck. But that leaves in place quite a few multi-member commissions with tenure protection, right? I mean, I don't know. Or Aaron, do you think that Humphrey's has been more narrowly interpreted now?
That outcome that you just said, that might very be where we end up. But that's going to be massive tension in the law. All I'm trying to say is, can you reconcile the two? And I think it's really, really, really hard to do, but for stare decisis, which I think is essentially what you're saying, even though, you know, it's maybe a different framing on it.
Basically, what you're saying is the court would have to be, the only way to reconcile these cases if the court says our value is that we're going to go with practice, even where it is in irreconcilable tension with the principles that we see in the constitutional structure, as stated in Saylor Law or Collins.
I think so. I don't think that they would be as you know, bold type as that in what they're saying they're doing. I think it's a nice misty haze about what's happening, but I don't see how you reconcile the two. I'd be curious what John or Melissa has to say, but I sure struggle to see how you reconcile them.
I have a thought, but Melissa, if you have something to say, don't.
Please, you go first.
I think that if you see this just as a question of removal, it is very difficult to see Humphrey's executor as anything but just being held in place by kind of pure stare decisis. And of course, the really important question of the FTC is a moderately powerful agency. But the really important question, there is a multi-member agency that is a whole lot more powerful than any of these, and it's the Fed. And what about the Fed? I do think, though, that, and here again, I'm going to put in a plug for the idea that there are means of presidential control other than removal. That one thing to say about Humphrey's executor and the FTC is that was just about removal. And Congress wanted the FTC, and historically this is clearly true, to be nonpartisan. And the court might say that that's a permissible goal. And even if reconciling removal doctrine requires that, well, you can't really say that Humphrey's executor was right about removal, maybe if Congress sets up a system in which the president has control over policy, but it has to be exercised in some way that will limit the ability to use it for partisan purposes, that would be permissible. And maybe under those circumstances, the question that didn't come up in Humphrey's executor, what about some other means of presidential control? Maybe there is a way to sort of integrate the unitary executive principle and avoiding partisan influence on decisions like the FTC or like the Fed, while saying, well, you know, what we said about removal is always in these cases where the only issue is removal, but maybe Congress has more flexibility about removal if they've given the president some other tool of control.
I thought.
I didn't catch that. Did you say?
Oh, I just asked if you had something to add.
Oh, no, I mean, I don't think I have anything to add beyond what they did. And I certainly, I think, struggled to see those cases being reconciled.
So I'm going to try to see if I can read some of the observations and questions over now in the chat function. Well, first of all, I should note that Professor O'Connell is on the call. So she heard Aaron's comments and said, you know, had thoughts on them, and also pointed out the acting questions that were sort of lurking in Collins that the court really did not address in great depth. So maybe Professor Nielsen, since you argued in the case, I mean, can you explain for the audience what the questions or what the issues would be related to the acting provision and how the statute might have addressed acting directors differently than confirmed directors?
Sure. So I already told a very complicated story, so I left out a piece of it. But here's the other thing. So as I'm giving the chronology of what's happening, throughout, sometimes you have a Senate confirmed director and sometimes you have an acting director. And in particular for the Third Amendment or the net worth sweep, that was done by an acting director. So my lead argument at the Supreme Court was, why are we even talking about removal here? Because surely the president can fire an acting director at will. The statute provides that the director has for-cause protection. It says nothing whatsoever about protection for the acting director. So, you know, absent some clear statement from Congress, why would we assume that there is a removal protection for this acting director? And the Fifth Circuit had disagreed with that. The Fifth Circuit said, because it's an independent agency, surely the for-cause protection applies to the acting director as well. That didn't seem right to me. And I thought that if there was a way that I was going to win this case, it was going to be on that ground to say, wait a minute, they're just wrong about this whole framing of the case. What then the court ends up doing is they say, this is an 8-to-1. Yeah, an acting director can be fired at will unless there's a clear statement from Congress otherwise. So yes, you know, the president could have always fired the acting director who did the Third Amendment. But because a Senate confirmed director came along later and implemented the Third Amendment, we're still going to continue to resolve all these really hard constitutional questions instead of just, you know, taking the off ramp that I gave the court, which, you know, I guess we can disagree about that one. It seemed to me that that was the easy, quick, clean way that's 100% right to resolve the case, which is just say an acting director has no tenure. This case is done, at least the constitutional part. That's not what the court did.
Anybody else have comments on that, John?
Yeah, I want to say that it's interesting that the court talked about that issue and didn't try to integrate its discussion of that issue with the statement that the removal restriction has always been invalid because the Constitution automatically invalidated it. But the argument that distinguishes between an acting director and a confirmed director assumes that the confirmed director is non-removable until the court says the confirmed director is removable, so that there's a difference between them. But if it's true that the confirmed director was always removable, even though nobody knew it yet because the statute said non-removable, then there's actually no difference between them.
So, John, I mean, on that point, just to try to clarify this for the audience and maybe myself, I mean, I think what you're saying, I mean, on one hand, it seems sort of frightening and broad to think that anytime the court finds a constitutional violation, it then has to believe that the constitutional violation has been ongoing for all time. I mean, objectively, that's got to be, I suppose, correct. But then, you know, at least speaking in my former government lawyer, with my former government lawyer hat on, you know, you start wondering, well, what happens, right? We're really saying then all these decisions were made by unconstitutionally appointed people. So what's the answer? Do we just ratify all the decisions by the properly appointed head after that's done, or properly removable head? Or I guess the other point you're making is, if we conceive of it as, well, it's not that it was an unconstitutional structure in place, because you can't actually have an unconstitutional law be operative. So it was always this different constitutional structure that was operating. Does that mean that under that view, I mean, I suppose, you know, some justices might still think there's compensable harm, but that in that world, that would actually make the implications of the decision a lot less far reaching? I mean, like, as a practical matter, what happens to all of the decisions in the past issued by the unconstitutionally tenure protected person?
Well, the first point is the principle of ab initio invalidity, which is what I'm urging, that if a statutory provision is unconstitutional, it never goes into effect, like the court said in Collins. The effect of that depends on different kinds of constitutional problems. And Justice Thomas talks about this a little bit in his concurrence. If there is a constitutional problem with somebody's appointment or power, then the principle of ab initio invalidity is going to flow through. The invalidity of the statutory provision will flow through to the power of the officer. And then, in principle, the answer will be that officer never had authority, never had a valid appointment, or never had statutory authority. And then, and the court has some doctrines to deal with problems like that, like the de facto officer doctrine, which they've moved away from in recent decades. But maybe as they start to think about the implications of ab initio invalidity, they might think maybe there's something to be said for that. But for other problems, ab initio invalidity means the problem never arises. And again, with the removal restriction, if it's true, as the court said, the removal restriction never goes into effect, then there never are any unconstitutionally non-removable officers. There can be unconstitutionally appointed officers, different kind of problem. But there, and again, Justice Thomas talks about this, he says it's kind of paradoxical that if the petitioners are right that this is unconstitutional, there was never a problem for them to point to, because it never went into effect. And then the question is, what doctrines, and this is going to come up on remand, what doctrines are the courts going to come up with to deal with the situations? Well, now we know what the law was, but a lot of people involved in all this didn't know about it. And again, Arthrex, to some extent, points the way on that, says, well, if what you didn't know about was some important procedure, you have to do it again with the right procedure. So yeah, the implications of ab initio invalidity depend on the constitutional problem. And then for a situation like Collins, they depend on just how much of this sort of counterfactual inquiry is it appropriate to conduct.
And we have hope that the justices will settle in a more definitive way on which approach they feel comfortable with, or do we anticipate more decisions like Arthrex, where actually the majority for the remedy was different from the majority on the substance of the merits of the case?
I wouldn't be surprised in two respects. I wouldn't be surprised if there are continued fractures on the severability fallback type issues when they arise after the initial constitutional decision. And then on these questions, like, what kind of rewind, as Justice Kagan says at one point, is appropriate. On those questions, I think it will take a while for them to sort that out. They don't get a lot of cases like this. They come in, I think, with different starting points on that. So it could be 30 years from now that they've actually sort of worked this through, because that takes some working through, and I don't think they're all starting from the same position. Look at what Gorsuch said in Collins.
Great. And one more question from the chat, I think a little bit more tied to what we discussed earlier, due process, or just the implications of, more political control at the top. In big enforcement cases, where hundreds of millions of dollars are at stake, or like with Lucia versus SEC from several years ago, somebody lost their license to be in their profession. Are the due process questions any different? Are the implications of Collins and Arthrex any more concerning or impactful in a big enforcement context, as opposed to just a smaller adjudicative decision or a regular policy determination?
Well, I would just say, when we think about PTAB, my initial thought process would be, even though this is just about a patent, it could be hundreds and millions of dollars that are at stake with invalidating the patent. So in some ways, I don't see it as so different in kind, at least the stakes that could be at issue with invalidating a patent versus a larger enforcement issue.
Right. So the stakes here were already pretty big. And I suppose, Aaron, that would be similar to your comment about Collins based on your initial comments that.
Yeah, I think so. This just is a bigger question. I think that, these are good ways to kind of think about it. It's like a new lens to see what's always been there. But this problem is not a new problem. So let's assume that the president doesn't have the power to control. Well, somebody is controlling it. And it's not in a court system, it's in an agency process. And, we didn't really get into the public versus private rights things, but if it's a private right, it seems kind of strange that you are now going through this process, whether it's the president controlling it or some non-presidential agency controlling it, where private rights are at stake. But that's just a whole nother very complicated issue. And I don't claim to know the answer to how to solve it.
So this has been a great discussion, and we really appreciate everybody's time. We have 3 more minutes remaining, and so I wanted to give an opportunity for each panelist to give us closing, parting thoughts, if you'd like. Aaron, we'll start with you.
Sure, I'll go first. I just want to say congratulations to both Melissa and John. We talk about winners and losers and all that sort of thing. Like, they're, in a sense, they're the winners of these cases. Melissa's and Chris's article, that's now what has happened. Now, I know that's not exactly how they thought it was going to get there, but that shows a little bit the power of scholarship. They thought about a problem, and that is where we have ended up. And with John, I was talking to John earlier before we even started, both of these cases, they redid how they think about remedies to reflect the arguments that John was making, which again, I think just shows the power of somebody who has an idea and sits down and thinks it out. So, we talk about the broad implications, whatever, put that aside. Just congratulations to the folks on this call who made a difference. So we say, does scholarship matter? Well, yes, I have 2 examples right now. See Melissa, see John.
Well, and let's add that, see Aaron, who was arguing.
But I lost.
Still, come on.
No, that's great. Aaron, that was a very good, that was a very good conclusion, actually. And I appreciate, Melissa, you also acknowledging Aaron's role, which, it's hard to, if you're a court-appointed amicus, it's because the parties with an actual stake in the case have decided they don't want to defend a particular view. So it's really the hardest hand to be dealt. So that was really great. And you had a lot of creative arguments that I'm sure were not necessarily in line with what your typical scholarly view would have been. And absolutely correct on Melissa and Chris Walker and John looking at problems, identifying possible solutions or ways in which the law needs to be rethought. And the court, went in a lot of ways that direction and built on those thoughts. So we're very honored to have you all here, giving your time to us here at the ABA to discuss these issues and try to have discussion as the law moves forward over the next few years and litigants continue figuring out how to bring these types of cases. Thanks, everybody. We hope that you enjoy your weekend and have a fantastic rest of the summer. And if you've got ideas of topics that the ABA Ad Law Committee, or in particular the Constitution Separation of Powers Committee, should be addressing, hit us an email or contact us on Twitter and let us know, because we want to keep having webinars that are helpful to your areas of practice and expertise. So thanks, everybody. Have a great Friday. Bye.
Thank you.
Hi, everybody.